morning, everyone. Welcome to WorkCover Queensland's Common Law webinar, where we will be discussing disclosure in damages claims. My name is Tim Loos. I'm a senior lawyer with WorkCover Queensland, and I'll be your host today. Joining me today at WorkCover Central are Kirsten and Elizabeth Bainbridge-Brown from Jensen McConaghy. And Elise behind me is from our comms team, and she'll be making sure everything runs smoothly today. Before we begin, I'd just like to acknowledge and pay our respects to the Yagara and Turrbal peoples as the traditional custodians of the land in which we work and from which we are speaking today. We thank them and their elders past and present for their ongoing connection to land, waters, culture and community. Just some housekeeping. We record the session and later on we'll send you a link along with the slide pack, and there'll be a short survey as well to gather your feedback. The session will also be uploaded to the WorkCover Queensland YouTube channel and via socials. Please feel free to submit questions during the webinar. There's a Q&A button in the toolbar at the top of your screen. We'll do our best to answer your questions at the end of the webinar, and we will be addressing some of the questions that have already been submitted at registration. We are unable to answer any policy or claim-specific questions, and we encourage you to contact your relationship manager if you have one, or to reach out to a customer advisor handling your claim or claims for your business for more information. Finally, if you have any technical issues, please refer to the help information under the More button, which you can find at the toolbar at the top of your screen. All right, now I'd like to introduce our guest presenters. First, we have Kirsten Weber, who's a partner at Jensen McConaughey Lawyers. Kirsten has over 20 years experience in defendant insurance claims. She has a particular focus on workers' compensation claims and has acted on behalf of state and national insurers and corporations. Welcome, Kirsten. Next, we have Elizabeth Bainbridge-Brown, who is a senior associate at Jensen McConaughey. Elizabeth has worked exclusively in defendant insurance claims. She regularly represents insurers and self-insurers and has a special interest in primary mental health injury claims. Welcome, Elizabeth. Before I hand over to our guests, I'd just like to remind our listeners that any information provided, including in response to questions today, by either WorkCover or Jensen McConaughey is general information only and should not be taken as legal advice. All right, that's all from me. I'm going to pass over now to Kirsten and Elizabeth. Thank you.
Thank you, Tim, and thank you to everyone for joining the webinar today. I just wanted to mention, that disclosure is actually a hot topic. It's been discussed previously but in WorkCover's webinar series. But for today's webinar, we thought we would dive a little deeper into the murky waters of disclosure. Just having a look at all the attendees today, we just wanted to let you know our discussion today is mainly directed to employers. So forgive me if some of this information is information that you already know. As you will see from the agenda, which is about to pop up on the screen, we will be providing an explanation today about why the documents we request are required, what we do with those documents, and very interestingly, some case examples so that you can see how the provision or non-provision of documents has impacted the outcomes of claims. I'm just going to start today by just providing a little bit of background for those attendees who don't necessarily have a lot of experience with workers' compensation claims and the common law process. As most of you would be aware, workers' compensation insurance is compulsory insurance for employers. The way claims are managed varies from state to state, but in Queensland, most employers hold workers' compensation policies with WorkCover Queensland. The way claims are managed is dictated by legislation. It's the Workers' Compensation and Rehabilitation Act, and there are essentially two components to the policy. The first is the no-fault claims process, where if a worker sustains an injury during the course of employment, WorkCover Queensland will pay for medical expenses, lost wages and rehabilitation. Those are the majority of claims, and I think in the 2022 financial year, WorkCover actually received just over 63,000 statutory or no-fault claims. So as this aspect of insurance is no fault, usually all WorkCover Queensland requires from the employer at that time is confirmation that the worker was indeed a worker, that there was an injury, and that there is a connection between the injury and employment. Most of the time as well, these claims need to be lodged no later than 6 months after the injury has occurred. The second component is what we call the common law process, and a number of no-fault claims will progress through to the common law stage. When you have a look at the number of common law claims that were instituted in 2022, you'll see that it's actually only about just over 4%, I believe, of common law claims commenced. There were just under 3,000 common law claims. So this is the stage when we, as WorkCover Queensland's panel lawyers, become involved. And in this common law process, the worker must demonstrate that the employer was in some way at fault. Common law claims ordinarily can't start until the no-fault claims process has been concluded. So it actually may be some time after the injury occurs that you are contacted by WorkCover and a panel lawyer requesting documents and information. It's typically no more than 3 years after the event has occurred, but there are rare cases where it has been after that time. As you'll see from section 280, from the slide presentation, section 280 of the Act provides that an employer must assist WorkCover Queensland by providing all information and access to documents in relation to the claim that WorkCover Queensland reasonably requires. Underneath that, you'll see section 279 of the Act, which details what documents are relevant to a claim. As you can see from the slide, it seems pretty straightforward. It's information about the circumstances of the event resulting in the injury, the worker's injury, and the worker's prospects of rehabilitation. So, what are relevant documents? Further on in section 279, there's some guidance on what a relevant document is. Reports and written statements are relevant documents. A written statement doesn't need to be a formal statement or a statutory declaration. It could be a handwritten note, a diary entry, an email, or even a text message. But as you'll see from the definition of relevant documents, there's a reference to other documentary material, which is rather broad. So in determining whether an employer is potentially negligent, we need to have a look at various aspects of how the business operates. And depending upon how the injury occurred, we need particular information about the training given, the worker's induction, and instructions provided to the worker about the task they were doing at the time of the injury, or what systems you had in place to minimise the risk of injury. We will also need to know if any changes were made to the system of work after the injury. A document isn't just a written record and can include photographs, video footage, and voice recordings. You might also get some strange requests from your panel lawyers, as we might ask to come and see how a particular task is undertaken, and we might film that task. It may seem like a very strange request because for you it's just a demonstration of an everyday task. And just as an example here, I have actually asked to observe how sausage rolls are made, but it actually does really help us and also the claimant's lawyers understand the task, and particularly when you tell us that it isn't possible for an incident to have occurred in the way that the worker claims. I've set out some examples in the slide of some other types of documents which might be relevant to the circumstances of the event giving rise to the injury. The relevance of the incident report or any investigation report is pretty straightforward. The incident report provides a contemporaneous report of the incident and what injury occurred. We can compare this to the description of the incident given in the notice of claim for damages. Sometimes the versions are different. CCTV footage or dashcam footage can be very helpful too. Unfortunately, however, common law claims may not be lodged for some time after the incident has occurred, and the CCTV footage may no longer be available due to storage capacity restrictions in employers' computer systems. We usually find that CCTV footage is retained if there's an event like a robbery or a slip and fall, but very rarely is CCTV footage kept of a worker undertaking a more common task, for example, reaching up high on a shelf or lifting a box of stock. If the worker claims that the injury occurred as a result of a failure by the employer to maintain plant and equipment, maintenance records are important to show how frequently the equipment was serviced and what repairs, or actually if no repairs, had been undertaken. Training records are also very important to demonstrate what training was provided to the worker on how to undertake a task, and this is particularly the case in manual handling tasks. It sometimes doesn't matter how experienced an employee might be, and we'll discuss this in one of the case examples a little later in the webinar. There can be quite intensive examination of the training provided to an employee and the adequacy of that training. And this is, as I said before, of particular importance with claims where the injury has occurred as a result of manual handling. In terms of documents relevant to the injury, many of those will be provided by the claimant, including medical reports. WorkCover will often have obtained some of its own medical evidence during the course of the no-fault statutory claim, but the employer will often have relevant records as well. There may be first aid records, and sometimes the employer will have arranged its own medical examinations in order to assess the worker's fitness for duty. As you can see from the slide, documents relevant to the injury is actually quite broadly interpreted and also includes information about financial loss. So an employer's leave records and wage information for before and after the incident assist us in assessing if the claimant has suffered any financial loss as a result of the injury. In terms of documents relevant to the prospects of rehabilitation, there is sometimes some duplication between documents relevant to the injury and documents relevant to the prospects of rehabilitation, such as first aid records, medical certificates and medical reports. If WorkCover coordinated the claimant's treatment and rehabilitation during the no-fault stage, your panel lawyer would already have been provided with many documents relevant to the prospects of rehabilitation. I might also just point out here that WorkCover actually has an ongoing obligation to offer claimants assistance with returning to work, which actually extends through into the common law stage. And any documents created then regarding return to work assistance are relevant to the prospects of rehabilitation and need to be disclosed. So one of the key questions that is often asked is, when are these documents to be disclosed? And the employer's duties under sections 279 and 280 don't start until a common law claim is commenced. Any documents that are relevant are required to be disclosed within 21 business days after we receive the documents. On occasion, we have seen requests before there is a common law claim from a claimant's solicitor to the employer, particularly requesting documents about the incident. If one of these letters comes across your desk, it's generally a good indication that a common law claim might soon be delivered. It's a good idea, when such correspondence is received, to consider if there is any video footage that should be saved. If the incident involved any plant or equipment which might be replaced, we recommend taking photographs of the equipment. If the work premises on site is about to undergo a renovation, photographs of the site as it was at the date of incident is also helpful. And also, I guess, if you're an employer who works on a building site, taking photographs at the time of the incident is also very important, because 3 years down the track, the development has been undertaken and the site is so different to what it was at the time of the incident. Just a reminder that there is no obligation to provide documents, as the disclosure obligations do not commence until the common law claim has been started. Depending on the severity of the injury, a claimant may ask their lawyers to assist them in lodging an income protection claim or a claim for total and permanent disability from their superannuation fund. In order to lodge a claim, the claimant's lawyer may need the employer to complete a form or provide some information for the purposes of that claim. It is usually okay for your HR or payroll department to attend to that request directly, but we always ask that you let your panel lawyer or WorkCover know that the correspondence has been received. Sometimes the request will come directly from the income protection or TPD insurer. Again, we recommend that you check with your panel lawyer or WorkCover Queensland, but usually it's okay for HR or payroll to attend to that request. And just that final bullet point there, if you are ever in doubt, check with your panel lawyer or WorkCover Queensland. So while it may feel like the obligation is all on an employer to disclose documents, the disclosure obligations under the Act are mutual. So the claimant has the same duty to disclose information. It's just that they usually don't have access to documents relevant to the circumstances of the incident, which is why we need to ask the employer for all those documents. The claimant is required to, at the time of lodging the common law claim, disclose copies of all documents supporting the claim. The claimant also has an ongoing obligation to disclose any further documents or information within 21 business days from receipt.
Following on from Kirsten's discussion, the next question you as the employer most likely have is how do your panel lawyers use that material that you have provided? Now, in accordance with the provisions of the Act and subject to the preclusions in 284 of the Act, which you can see set out on the slide there, your panel lawyers are required to disclose relevant documents and information to the claimant solicitors, but also to the other parties that may be involved in the claim. Simply, this means that the other parties will be provided with copies of the documents that you have provided to your panel lawyers to enable them to review and consider that information as well. Now, part and parcel of this process involves your panel lawyer reviewing the disclosure to ensure that it is indeed discoverable in accordance with Section 279, to ensure that it does not infringe on non-disclosure obligations under 284. Now, this could be a piece of legal advice that you've obtained from another lawyer, and also to ensure that it does not infringe on the privacy of other individuals who are not the subject of the claim. Now, this last element can be difficult, as whilst ensuring confidentiality is essential, there may be relevant information concerning other workers, such as comparative earnings, and incidents of a similar nature may be discoverable if it is directly related to a matter in question. In those circumstances, your panel lawyer may request that information directly from you and then may take steps to redact any information that is not required to be disclosed before providing it on to the other parties. Your panel lawyer may often request comparative earnings from other employees, usually in the form of 3 employees, to assist in assessing future economic loss by way of understanding what rate of pay the claimant may have continued to receive if he or she remained in employment with the employer. These records will be de-identified to ensure that there are no personal identifiers. You can see that we've listed a matter of Healy and Logan City Council there on the slide. In that matter, the plaintiff had requested from the defendant comparable earnings from other employees. The court confirmed in that case it was not appropriate for those records to be provided in circumstances where the defendant had actually advised the plaintiff and it was accepted by the judge that there were no such comparable earnings. In this case, the employees were all cleaners, but they all worked casual and very different hours, such that there was no such comparable employee. Similarly, records which show that there have been or there have not been prior incidents of a similar nature may also assist your panel lawyer to assess whether a risk of injury was or was not reasonably foreseeable. A further advantage of early and full disclosure by the employer is that it will enable your panel lawyer to identify if there are any other additional parties that may be liable to the claim. At the very early stages of common law claim, the claimant or your panel lawyer may not yet be aware of all possible parties to the claim, and your advice to us, a disclosure confirming that, say, the incident occurred on a site not owned by you or operated by you, or where the claimant was required to work in accordance with another party's system of work or under their control, or that the claimant was operating machinery that was serviced by or controlled by another third party, is crucial. Now, the Act sets out relevant timeframes within which WorkCover Queensland can add additional parties to a claim. Of course, if at a much later stage in the matter a further party is identified, this is something that your panel lawyer can deal with for you. By way of example, I received urgent instructions from a client who had an application proceeding in the court the following day. Now, the client worked with me very quickly to obtain documents relevant to the claim, and we were able to identify and provide to the claimant solicitor's disclosure which showed that the incident occurred at a different site that was owned and operated by a third party, and we were also able to identify the principal contractor of the site. So we provided that disclosure to the claimant solicitors, and they took steps to amend their application to join those additional two parties to the claim. Now, in that matter, His Honour was quite appreciative of our client's disclosure and commented that those documents certainly were suggestive that the client's involvement in the matter would be minimal, and the two additional parties were successfully added to the claim. A common question we also receive regularly from employers is, what happens if I don't have any documents in support or denial of my claim? Now, this might occur if the employer has recently been bought out or taken over by another company, or in recent years as a result of the flooding in Queensland, where we've seen many records destroyed. It might also occur if you are a small employer just starting out and you have not yet implemented any documents or systems of work. Now, obviously, from our position, best practice is to always have documents to support your position. However, there are certainly things that we can do to work around these issues. The first step for us is to identify whether there is a current representative of your company who can speak directly to the circumstances of the incident, the system of work, any policies or procedures, any instructions or level of supervision provided to the claimant, and to take a statement directly from that person. Secondly, it might be possible for us to take a statement from an ex-employee who might also be able to speak to those relevant matters and provide a statement. Thirdly, it might be the case that the employer is aware that the claimant would have relevant knowledge about the incident, perhaps about the level of training or supervision that that person had received. And in those circumstances, your panel lawyer can deliver a Section 279 request for information to get that information from the claimant directly. For example, a request could be made to the claimant to confirm if or when they had reported any issue to the employer, and this would assist your panel lawyer in assessing whether or not the risk of injury was reasonably foreseeable. It may also be possible to obtain records from a third-party provider. This might be something we do if we're looking at a piece of equipment that may have had a maintenance conducted on it. There might also be a third-party provider that had provided training to the claimant, and we can seek those records as well. It is important to note at this stage in the matter that if there are in circumstances where there is no evidence to contradict the claimant's version of the incident, so there might be no witnesses and no documents at all, and where the incident was contemporaneously reported to the supervisor or to a medical practitioner, a court may be inclined to accept the claimant's version of the events. Now, with this in mind, from a claim management perspective, and depending on the quantum and the circumstances of the claim, it may then be appropriate to discuss and approach the claimant solicitor on a without prejudice basis and advise that there are likely no liability documents to be disclosed. And then we can take steps to progress the claim to informal discussions or to a conference at an early stage. If it is necessary for WorkCover to deliver its formal liability notice, such notice may be delivered on the basis that investigations are ongoing. Now, this might be appropriate if your panel lawyer considers that further information may be gained by way of a further request once the matter is litigated. Your panel lawyer will have a greater level and greater ability to obtain records from third parties in litigation. However, if there is no reasonable basis to defend the claim, it may also be appropriate for WorkCover Queensland to deliver an admission of liability. This would result in narrowing the issues before the parties. Liability would not be further agitated, and the parties would then be focused on the issue of quantum only. Now, in common law matters, the burden of proof, which is the level of which a matter must be proven, is on the balance of probabilities. And this can be compared with the criminal burden of proof, which is beyond reasonable doubt. As you can see by those definitions, the burden of proof in our common law claims is a much lesser burden than that in a criminal matter. Now, the burden of proof is something that falls on the plaintiff and means that the plaintiff is required to introduce evidence that supports his or her case. However, if the employer wants to raise an alternative scenario or a defence or claim that the claimant has contributed to the incident, then the employer will need to introduce that evidence. Now, once we've received information and disclosure from you, The panel lawyer will then forensically analyse the material in conjunction with the claimant's allegations regarding the circumstances of the incident and the allegations of negligence to assess the merits of the claim. Now, ultimately, what we're doing here is providing you with an answer as to whether or not we consider the employer is liable for the injury sustained on the current available evidence. Now, to do so, your panel lawyer will consider a number of things. You can see a few of them sitting on the slide there before you. So firstly, what we look at is whether the incident occurred as alleged or at all. By way of example, in the course of managing a recent common law claim, the employer flagged with me in the initial phone conversation that they did not believe the incident occurred as alleged, but rather that the incident was caused by an act of horseplay by the worker. The employer was able to locate 2 witnesses who had actually witnessed the incident and who were happy to speak to me and were able to provide us written statements to confirm that the mechanism of injury was not as suggested by the claimant. Now, those witness statements were also supported by hospital and GP records, and ultimately the claimant withdrew their claim following our denial of liability and confirmation that no offers of settlement would be made. Now, the next thing we look at is whether the risk of injury was reasonably foreseeable. In this regard, the court suggests that consideration must be given to whether the risk of injury was not far-fetched or fanciful and not insignificant. Now, in assessing this, your panel lawyer will be considering the circumstances of the incident as well as relevant case law. The next 2 matters on the slide are linked. We're looking at whether the injury was preventable. And in this regard, the onus is on the claimant to establish a reasonably practical alternative system to that which was actually used by the employer. And then linked to that, we have to consider what was the reasonableness of that alternative system. Now, reasonableness is determined by looking at the magnitude of the risk and the probability of its occurrence, along with the expense, difficulty, and inconvenience of taking alleviating action. Now, by way of example, if a claimant was injured by reason of a piece of machinery and the plaintiff then suggested that he or she would not have been injured if the employer had installed a brand new state-of-the-art machine, the panel lawyer may come to you to seek your response regarding the potential cost of a new machine and whether purchasing a new machine was practical for the business due to the financial status or business operation status at that time. Now, if we can show and establish that purchasing a new machine was not reasonable or practical, the claimant may struggle to establish this limb. However, on the flip side, if the claimant was injured by reason of a significantly outdated piece of machinery, which is not compliant with current rules or regulations, this may prove fatal to an employer's defence of liability. And alternatively, again, if a claimant suggests that the injury may have been avoided by reason of installation of a guardrail or provision of safety goggles, such matters would likely be considered by a court to be considered reasonable, inexpensive, and the failure of the employer to supply those items may be the basis for a finding of negligence. Now, one of the last things we look at is causation of the injury and whether the claimant's injury was caused by the risk in question. Now, it is a matter for the claimant to prove that any breach by the employer was a material cause of the injury. Now, all of these matters are obviously complex and require a close examination of the facts and the circumstances, and your disclosure will be key to this. As mentioned by Kirsten earlier, requests for disclosure from the employer may occur throughout the course of the common law claim, not just at the start. Commonly, further requests for disclosure may occur at the commencement of litigation and or anticipation of a further conference. You can see on the slide Rule 211 of the court rules, which set out that the obligations of disclosure remain ongoing throughout the claim and subject to the same time frames under the Act. Now, if a common law claim proceeds to a compulsory conference and remains unresolved, it is highly likely that litigation will be commenced. Now, if litigation is commenced, your panel lawyer will be in contact with you to discuss any new allegations and your response to those matters. The panel lawyer will also be in contact with you to discuss the contents of any defence to be filed on behalf of the employer and WorkCover Queensland. Now, certainly at this time, it is quite common for there to be further requests for disclosure from the claimant's legal representatives seeking to refine their case and to further articulate their position on liability. At this stage, panel lawyers may be looking to you as the employer to provide specific input and instruction regarding industry-based knowledge. Your input at this time is absolutely crucial, as whilst matters may appear simple or straightforward to you, they may be outside the knowledge of your panel lawyer or counsel. Now, at this point in the presentation, we thought it would be beneficial for us to provide you with some real-life practical examples of how your disclosure can have a significant bearing on the outcome of a matter. Now, Kirsten and I will now run through a number of matters which we have either run to trial over the years or some matters which, whilst we did not run, deserve some consideration as well.
The first claim is a little bit of an oldie but a goodie. It's, as it was from 2012, it's a decision of Sanders PTY LTD and Schmidt. You'll see the factual circumstances there on the slide. So he was a 64-year-old truck driver who was very experienced, with 20 years experience as a truck driver, and he'd also owned and operated his own vehicles. Until working for this employer, he hadn't driven this particular prime mover that he was driving at the time of his injury. It was a dark and stormy night, and he slipped and fell while exiting from the cabin of the prime mover and sustained injury. So it wasn't his first time using the prime mover while working for this employer, and there was actually evidence that on that particular night, he had successfully exited and re-entered the cabin several times without incident. However, his method of exiting was inappropriate, as it resulted in him losing one of his 3 points of contact. The evidence he actually led at trial was that despite his many years of experience truck driving, this was the way he got in and out of the cabin of the trucks. Essentially, there were two key allegations of negligence. The first one was that the employer failed to ensure that there was sufficient slip resistance on the tread of the step, particularly because it was wet when the incident occurred. So the allegation was that the employer failed to provide proper plant and equipment. In this matter, the employer was actually able to provide evidence that this particular truck had been specifically purchased for its recognised safety features, and there was also evidence that there was no evidence of complaints from the other truck drivers, including the plaintiff, about any slips or falls using the steps. So the employer was actually successful on that allegation of negligence. However, the second allegation of negligence was that the employer failed to provide instruction to the plaintiff on how to safely access and exit the cabin of the prime mover. If the employer had evidence that it had provided the plaintiff with training on how to get in and out of the cabin, or had done an assessment of his capabilities and competencies on his induction, it may have succeeded in the claim. There was no evidence of any assessment on the method of him accessing and exiting the cabin, and if they'd done so, they would have seen that he didn't do it properly and didn't utilise the rule of 3 points of contact. So unfortunately, because the employer failed on this allegation of negligence, they were ultimately unsuccessful in the claim.
Now, this is a matter of Solomona and Number 1 Riverside Quay. This is actually a matter that Jensen McConaghy ran to trial back in the Southport District Court in October 2016. We've set out the facts of the matter on the slide before you. Ultimately, this was a plaintiff that suffered a lower back injury when she attempted to lift a basket of ice creams out of a freezer and the basket became stuck, presumably by reason of a build-up of ice. Now, it was the plaintiff's case that she had not received adequate or any training for this task. Now, you can see on the slide that there was judgment for the defendant employer and there was no finding of liability for the reasons listed there. The reason why disclosure was quite key in this case, as the disclosure provided by the employer confirmed that the plaintiff had indeed received manual handling training, and the trial judge was satisfied that this was sufficient for the relevant task and concluded that the employer's system of work and policies were entirely proper. Another unusual element of this matter was that in the course of our routine investigations, we discovered that the plaintiff was in fact running an online business. Now, this was raised by our counsel during cross-examination at the trial, and under cross-examination, the plaintiff conceded that she was indeed running a small online business, and she could not explain to His Honour why she had not disclosed that information before the trial. You can see that the judge was not particularly happy with the plaintiff in this respect, and this decision certainly serves to reinforce that the duty of disclosure remains ongoing for both parties, and that the plaintiff can certainly get into hot water for failing to act in accordance with their duty of disclosure.
The next decision that I will discuss is a matter of Francis and MSF Sugar Limited. It's one from 2020. The facts are set out on the slide, and as you will see, the plaintiff sustained an injury to his arm in October 2013. Liability had been denied, and some 6 years after the incident, the claim was set down for a 4-day trial. A key document was found, which had been in existence since October 2013, but didn't come to light until just before the trial in 2019. The document actually showed that substantial parts of the defence were untrue and that there actually might be some other relevant documents which had not also previously been disclosed. Now, in terms of the judgment and impact of disclosure, the judge, when determining the matter, made some quite scathing comments about the defendant's failure to disclose the documents until a late stage. And also for making allegations in the defence that were ultimately proving to be false based upon that disclosure. He was critical of the fact that the failure to disclose likely delayed determination of the claim, and actually, if that document had been disclosed in a timely and appropriate fashion in accordance with the disclosure requirements under the Workers' Compensation and Rehabilitation Act and the court rules, the matter probably would have resolved much earlier than 6 years down the track on an agreed basis without the need for any trial. A consequence for the defendant was that they were ordered to pay some of the plaintiff's legal costs, and this case highlights the absolute requirement for parties to comply with their obligations of disclosure.
Next, we have the matter of Potter and Gimpy Regional Council. Now, this is another matter that Jensen and McConaghy ran to trial in early 2021. Now, as compared to the prior examples, this matter concerned a pure psychiatric injury rather than a physical injury. You can see that the plaintiff was employed in a managerial role, and he alleged that he'd suffered a psychiatric injury over a period of time as a result of a number of matters. Now, throughout the course of the claim, the employer was able to provide us with significant material which provided the basis for our defence of the claim. Now, in particular, one key witness who was in attendance at the various critical meetings with the plaintiff was able to supply his work diary to us, which provided significant detail about those meetings. Now, in circumstances where the trial occurred about 7 years after the subject events and the witness's recollections had faded somewhat, this witness was able to point to his diary as an accurate record of what had occurred back at the time of the incident, and the court was satisfied and accepted that he was a witness of credit. A second element of disclosure in this case was that the employer had actually engaged a third-party investigator to investigate the misconduct allegations by the plaintiff. We were able to obtain directly from the third party copies of the voice recordings of the interviews, which were conducted in the investigation back in 2014, and it included an interview with the plaintiff himself, which provided particular insight into the plaintiff's behaviour and response to the allegations at the time of the incidents. The employer was also able to supply us with relevant policies and procedures, which informed its investigatory process, which was significantly in dispute in the claim. Now, you can see on the slide that there was judgment for the employer defendant in this matter. It was actually found at the trial for the defendant and also at the Court of Appeal decision. And the judge concluded that there was no breach by the defendant for the reasons set out on the slide. Now, disclosure was key for the reasons that I've mentioned, particularly because the diary entries of the witness were able to be supplied, and they highlight the importance of making contemporaneous notes about relevant matters as they occur. The voice recording of the interview with the plaintiff was also quite critical in this matter, as we were able to combat an allegation that a certain comment was made by the plaintiff. This was a matter that was directly an issue in the pleadings, and the video recording, an excerpt of which we actually played at the trial, confirmed that the plaintiff's allegation was inaccurate. Now, this matter shows you that some matters, unfortunately, may be on foot for very many years, and by the time a trial occurs, witness recollections may have faded, and it may be difficult for them to give evidence about the relevant matters. Now, what this matter teaches us, among other things, is that best practice is to document critical meetings or discussions as they occur, and to ensure that those records are kept safe.
The next case example is, let's call it case study A, is one where the plaintiff was actually injured at work in May 2011. He claimed to have suffered a lower back injury and a secondary psychiatric injury. At the time of the injury, he was pulling a large wooden credenza, which weighed about 50 kilograms, on a trolley up about 20 steps with a co-worker. The reason he was doing this was that the employer was actually moving premises, and they asked him to assist his co-worker in moving some furniture around. Early investigations were undertaken and a factual investigator was appointed, and various statements were obtained from the staff of the employer, including the co-worker. Unfortunately, there was no evidence that the plaintiff had been provided with any manual handling training, and this was actually because the task he was undertaking at the time was not something he would have ordinarily undertaken during the course of his employment. Proceedings were commenced in the Brisbane District Court in 2013, and because it looked like there was no evidence to support a finding no evidence to support that the employer would be successful in the claim, liability was admitted in the defence. The evidence at that point indicated that there was a significant claim, as he had stopped work shortly after the incident, claiming that he was incapable of undertaking any employment into the future. The defendant at that time made a substantial offer to try and resolve the claim, and the plaintiff didn't accept it. After that offer was made and rejected, and we were preparing for trial, the plaintiff disclosed that he was earning a little bit of pocket money selling items on eBay. He claimed it was only a hobby and that he wasn't earning enough money to warrant lodging a tax return, and certainly not enough to live off. In this instance, because he didn't have any tax returns, which usually assists us in assessing financial loss, we were able to obtain access to his bank records, which showed that he had more than just a little eBay business. We obtained a report from an accountant who confirmed that the level of business activity he was undertaking meant that it actually fell outside the tax office's definition of a hobby, and he should have been lodging tax returns and declaring his income. As part of the plaintiff's disclosure obligations, we were also able to obtain an order from a judge that he open access to his social media accounts, which had been set to private. Despite the court order, he refused to do so. As he failed to comply with a court order to disclose a relevant document, the court dismissed his claim. It ended up that WorkCover was able to recover some of its legal costs spent in defending the claim, and this case example reinforces that disclosure obligations are mutual and that the plaintiff has an ongoing obligation of disclosure as well. This is another claim where, if the plaintiff was successful, there was a potential for a substantial award of damages. It may seem like every case example we're giving you, there are claims that the claimant alleges that he or she or they will never be able to work again. These are just some extreme examples. It's not the case for every single common law claim that occurs. For case study B, this is one where a truck driver had picked up some gravel and was driving a prime mover and trailer loaded with that gravel to another site. He arrived at that site and proceeded to unload the gravel. He had to move the prime mover and trailer backwards and forwards while unloading it so that the gravel was spread evenly on the ground. He didn't do that brilliant a job because as he reversed, he drove over a gravel mound which he had created and the truck and trailer rolled over. There was a spotter on site, but the claimant alleged that the employer was negligent because the spotter was not in a correct position and provided no warning of the presence of the gravel mound. So as you can see from that last bullet point, he suffered a lower back injury and a secondary psychological injury and claimed he would no longer be able to work as a truck driver. We were lucky in this instance in that the employer had the foresight to preserve the truck cam video. There was a recorded conversation between the spotter and the claimant where the claimant shouts out to him, "I hope it won't go over," and the spotter responds, "You're on a bit of a lean there, mate." And the claimant says, words to the effect of, "If the truck falls over, it falls over." 30 seconds later, the truck rolled. When we disclosed the recording to the claimant, he withdrew his claim. So this case example emphasises the importance of early identification and retention of the documents. We were very lucky in this instance that the employer had a bit of an inkling that this might progress further down the track and actually retained that truck cam video footage.
Our last case study for today, case study C, concerns a lower back and secondary psychiatric injury, which the plaintiff allegedly suffered as the result of lifting and carrying a large item with a co-worker. Now, this was, once again, as Kirsten has mentioned, a claim advanced on the basis that this person could not resume any employment ever again, and there was a significant damages claim advanced. Now, from the very early start of this claim, we did have some initial concerns in circumstances where the notice of claim for damages was actually delivered about 2 years after the event. Now, that in itself is not unique. Sometimes it does take some time for a claim to come through, but this was a bit different in circumstances where throughout that period, the plaintiff had actually commenced a number of other claims during that period for separate injuries both before and after the alleged date of injury, but just not for this specific date of injury. Another issue for us from the early stages was that the plaintiff had provided various inconsistent versions of the event, as well as varying dates of the incident and varying locations of the incident. And lastly, a large gap in the evidence, as we saw it, was that there was no corroborating statement provided by the co-worker, despite us being told that this would be provided to us. Now, the employer was able to work with us and obtain a lot of disclosure for us in this case, and they were able to confirm for us that the plaintiff and the co-worker were not employed to carry out the subject's task to start with. Service logs were provided which confirmed that an item weighing about 100 kilograms was not actually delivered to the site on the relevant day. We were able to confirm that the plaintiff and the co-worker were not actually working at the subject address together on the date of incident, but rather they were many hundreds of kilometres apart. And lastly, we obtained evidence which suggested that the large item was in fact delivered to the site by a third party. Now, in the course of managing this claim, we handed over disclosure of all of this material very early in the piece. Despite this, the matter proceeded to conference. The conference was unable to resolve the claim and litigation was commenced. Throughout the course of managing the claim, we sought disclosure of the statement from the co-worker, but again, it was not provided to us. Now, at this stage, we took steps to set out WorkCover's position to the plaintiff solicitors in writing, and we provided our position set out with the disclosure again, and we advised at that time that no offers would be made in circumstances where the evidence before us did not support the plaintiff's version of the incident. Now, ultimately, the matter was set down and listed for trial, but on the eve of trial, the plaintiff delivered an offer to resolve on the basis that the proceeding be dismissed. Now, certainly in our view, this was a great result for WorkCover and the employer, and the disclosure that we had obtained and disclosed revealed in our view that the incident did not occur as alleged, and the matter was able to be successfully resolved by WorkCover on that basis.
So I guess just in summary, what we wanted to give you is some key takeaways. So whilst some common law claims are unexpected and do come out of the blue, many employers have commented to me that they were pretty sure that there would be a common law claim arising from an event. In those instances, we ask that you turn your mind to preserving material which might otherwise be lost, such as CCTV footage and other contemporaneous records. As you can see from our case examples, disclosure is very important, and we don't want to be taken by surprise by a document which turns up many years after the event, such as in that case of Francis. And just a reminder that the obligation is on all parties to disclose, even though it may not feel like it.
All right, we're going to do some questions now. We have a few that came through at the registration stage. Those will be up on the screen. I think those are good starting points for further conversation. Are you happy to run with those ones?
Yeah. Yep, thanks, Tim. Just in response to the first question, which is how important are records for training performed and file notes, my response to that is it does depend on how the injury occurred. But in most claims, training records and file notes can be very important. The Solomona case example that we referred to before is a good example where evidence of the extensive manual handling training provided by the employer was key to the plaintiff losing her case. And in Potter, the file notes and voice recordings were critical documents in which we were able to successfully defend the claim. In response to the second question there, I know I'm giving a bit of a lawyer-like answer because, again, my response to that is where a third-party legal firm are requesting for claim-specific queries, can we submit the information requested through WorkCover Queensland? It really does depend on what sort of claim information is being requested. If the request relates to a common law claim, the panel lawyer will assist in any claim-specific queries that you might receive from a third-party legal firm. And I just wanted to remind the person who asked this question that the employer's duty of disclosure doesn't actually start until there is a common law claim.
Okay, turning to the third question on the slide, why is information on claimants' previous claims disregarded in common law claims? As a starting point, this is a very broad question. As discussed today, the meaning of relevant information is quite broad. It's also a bit of a difficult question for us to respond to without further details. But in short, certainly in my experience, panel lawyers do not, as a matter of course, disregard information about previous claims. We would say the opposite is true. Certainly, in our view, all relevant information is considered and utilised in both our assessment of liability and quantum. However, what might be the issue here is that your panel lawyer may choose to give different weight to different information depending on the various elements of the claim and the various particularities of that claim as well. So I would suggest that if you have a particular question, that might be best addressed by your panel lawyer, as it will vary from claim to claim. More generally, if there was, say, a history of prior injuries, this is something that would certainly impact upon our assessment of the quantum of the claim. And if there were, say, records of prior similar incidents or a history of making claims, this is something that would have a bearing on our assessment of the claimant's credibility, which may also impact upon our assessment of liability and quantum. Turning to the last question on the slide, what happens to disclosure obligations when a suppression order is granted? Again, this is a very large and very interesting topic. We could probably run another CLE just on this topic alone. For anyone that's not familiar with a suppression order, what this means is that a party can apply to a court for an order that a party be entitled to withhold from disclosure certain documents. Now, to be successful in obtaining an order like this, the judge must be satisfied that it is appropriate to do so. This is usually on the basis that there might be a reasonable suspicion of fraud. Now, if a party is successful in obtaining an order for suppression, the duty of disclosure may be altered, depending on the terms of the order sought. Now, that party can seek relief from an obligation to disclose certain documents until after the close of the plaintiff's case at trial. Now, this is certainly one example of where the obligation of disclosure is modified, but it will very much depend on the terms of the order sought as to what type of documents can be withheld.
Thank you very much. We've had a few more questions come through over the course of the webinar, so I'm going to put you on the spot now with some that you haven't heard yet, but we'll all just do our best. The first question is about do we need permission or consent for voice recordings? And that's something we come across a lot internally in the legal team to do with the stat claim, and we're always very careful in our response because getting it wrong could potentially lead to an offence. Can you talk through using voice recordings or recording in the first place?
Well, I guess again, it really depends. Usually the party who is making the recording is a party to the conversation, so they are certainly entitled to keep a record of it. Most times, I guess, as an example, in the Potter case, the conversations were recorded, and that was with the agreement of all the parties present there. There are issues, certainly, Tim, as you would be aware, that conversations can't necessarily be secretly recorded, particularly if the person making the recording is not a party to that conversation.
And then I understand there's some rules around what you can do with a recording, even if you're a party to it. And I think is that the Invasion of Privacy Act, Queensland, I believe?
I think you might be right. I can't remember the precise name of the act. Yeah.
But anyway, that's where you find the basis for the rules around that. The second question: what happens when a client or employer, I suppose, refuses to share CCTV footage, or I suppose any sort of disclosure?
Yeah, we actually have. It's not necessarily a client who refuses to provide the CCTV footage. It's often a third party,
right.
And we can't access that CCTV footage because, and I say third party, but I guess it's a party. It's an entity, not a party to the claim. So, by way of an example, if you have a worker who has slipped and fallen on a third-party site. Let's say, just as a pure example, because it's a great example to give, shopping centre, because there's CCTV footage everywhere in a shopping centre. We usually can't access that CCTV footage during the pre-proceedings stage unless the shopping centre or the owner of that CCTV footage is joined to the claim as an additional party or an additional respondent. In that instance, what sometimes, if we do consider that the information is critical, often we need to wait until proceedings have been instituted by the claimant, and then there are powers under the court rules where we can access information from other parties.
And to add on to Kirsten's comment, I have actually had this occur recently in the management of a common law claim, and we were able to obtain the CCTV footage prior to litigation commencing. But the way we were able to do that was through help from the employer. The employer actually made the request directly to, I think it was a shopping centre in my matter, and they sought their agreement, and the employer got the material and then provided it to me. And it was critical, and we were able to resolve the claim at the early conference stage because of that disclosure.
Good outcome. One more that we've jotted down, and turn your mind back to case study B, if you will. So the question is, in relation to that case study, why was this run to trial by counsel, given that disclosure should have provided insight into the camera and recording?
Well, Tim, it actually didn't run to trial. So it was actually the claimant actually withdrew his claim at a very early stage, right, during the pre-proceedings process. So it was actually very shortly afterwards, which is kind of why also we've referred to it as case study B, because it never actually made it to trial and there were no decisions and no proceedings on foot. Very
good answer. We've actually run out of time. I had a few questions of my own, but they were sort of very generic procedural things. So thank you very much. That was excellent. Really good information, and really appreciated the way you tied it back to our audience, who are mostly employers. So that's fantastic. Thank you. To everyone listening, as mentioned earlier, this session has been recorded. It'll be sent out to you shortly and uploaded to the WorkCover Queensland YouTube channel, where you'll find all our previous webinars in a dedicated playlist. And we're also going to gather your feedback on this session via a short survey. So thank you for participating in that. If you're interested in attending any more of our webinars, please keep an eye out in your email, LinkedIn, or the events page on the WorkSafe Queensland website. And that's all from us. Thank you all very much for listening in. Thank you, Kirsten. Thank you, Elizabeth. Thank you, Elise, for running the show. We'll see you next time. Thank you.